We begin tonight with Pike River and the Court of Appeal. Nigel Hampton QC has been arguing that the decision to not prosecute Peter Whittall over the deaths of 29 men in the mine was unprincipled and unprecedented. The Pike CEO did initially face 12 health and safety charges relating to the explosions, but that prosecution was dropped after an insurance payout of $3.4 million in total to the victims' families. Two of the families who angrily believe that money superseded the legal process and that it denied them the chance for true justice have been appealing against it. Their lawyer, Nigel Hampton, told the Court of Appeal the payment, made without the involvement of any of the families, was designed to buy off a prosecution.
That's the whole point of the issue. Whether, as they did, MB were entitled to take that payment into account as a proper factor in public interest, on public interest grounds, influencing their decision to withdraw or not. Our argument is that money like that, a payment like that, conditional on the charges not proceeding, can never be taken on account, and the actual sum of money doesn't matter. It's the offering of a sum of money on condition that the prosecutions are not proceeded with, which makes it, in our argument, unlawful.
So there has never been a trial of any description, setting aside the Royal Commission. There has never been a court case in which Peter Whittall has been cross-examined, for example, and there has been a formal judicial consideration of how 29 people died in what the Royal Commission describes as a preventable accident. No,
there's never been a case. They decided that they had enough evidence to take criminal nuisance charges under the Crimes Act, but decided not to because by then MB had taken these 12 charges under the Health and Safety and Employment Act against Peter Whittall, and so they decided they wouldn't take the criminal nuisance charge. They didn't want to expose him to double jeopardy. But then, of course, subsequent to that, this offer of money came along, and the health and safety charges fell over as well. So no criminal charges, whether under the Crimes Act or the Health and Safety and Employment Act, have ever been brought before a court and tried.
Which, in the circumstances, an explosion in a mine regarded as preventable in which 29 people died seems unusual.
Well, you're being mild in your description of it. Yeah, and furthermore, Mr. Whittall didn't, when it came to the Pike River Royal Commission in phases 3 and 4, where the real issues about the conditions underground and what might have led to the explosion and the death of the 29 people, he didn't give evidence in front of the Royal Commission on those substantive issues. So we've never had an account from him, whether there in front of the Commission or anywhere else, as to his role leading up to and during those events.
So taking all of that into account, as a precedent, in terms of workplace safety, in terms of culpability, in terms of the responsibility and the buck finding somewhere to stop, what does this tell people who work in situations where there are dangers?
Well, there are two aspects. The decision, we argued, the decision to withdraw the charges or not proceed with the charges leading to them being dismissed was unprincipled and unprecedented. Unprecedented because it is so against what a secure and principled justice, criminal justice system should stand for. Secondly, in weighing their public interest factors before deciding not to offer evidence, the MB, and this is again part of the argument in court today, failed to take into account their responsibilities to administer and enforce the health and safety legislation, their role in that, and to make sure that people abide by the legislation and that their employees are safe and that are held accountable if needs be that part of it never entered into their consideration of public interest, and that, we say, was a fundamental failing as well. So it's rather a negative view that one could take of enforcement of health and safety responsibilities.
Just before you go, it's an expensive business to go to the appeal court, and my understanding of both Sonia and Anna's situation is that they don't have terribly much money. How is this appeal being mounted? Who is paying for your time?
I'm paying for my time. This is being done pro bono, and lawyers do have social consciences.
And is that why you're doing it? You feel that this is so important and so egregiously wrong that you are prepared to do this without payment?
I feel so exercised by it that I would do it without payment, and have done it without payment both in the High Court and here.
Nigel Hampton QC talking to me earlier.